Recently, the Supreme Court ordered the release of Rajiv Gandhi's assassination convict A G Perarivalan by exercising its power under Article 142 of the Constitution. This extraordinary power vested with the apex court is not used routinely. Only exigent circumstances that warrant the interference of the highest court of the land to prevent any gross violation of rights and to prevent any explicit miscarriage of justice see the court invoking this unique power. In this video, we will try to explain more about this special power that has come in the news after the release of A G Perarivalan. We will try to apprise of all the relevant facts about this extraordinary article. As everybody knows, the Supreme Court has been conferred with supervisory jurisdictions on the courts and tribunals lower to it. In order to see that the orders passed by the subordinate courts are in accordance with the ideals of justice, equity and equality. This power has been bestowed upon the top court by the virtue of Article 142 of the Indian Constitution after a wide debate in the Constituent Assembly. The Constituent Assembly felt such power vested with the Supreme Court will ensure the top court will act as the guardian of liberty and rights of the citizens. The framers of the Constitution felt that this provision is of utmost significance to those who have to suffer due to the delay in getting their necessary reliefs due to the disadvantaged position of the judicial system. In the Constitution, there are no specific rules or procedures or circumstances mentioned that needs to be followed by the Supreme Court to invoke this article. According to Article 142 of the Constitution, the Supreme Court in the exercise of its jurisdiction may pass such a decree or order as is necessary for doing complete justice in any cause or matter pending before it. So, in a nutshell, Article 142 provides a unique power to the Supreme Court to do complete justice between the parties where at times laws or statutes may not be able to provide a remedy. In those situations, the court can extend itself to put an end to a dispute in a manner that would fit the facts of the case. Also, another significant aspect of this unique power is that since it is used sparingly and under extraordinary circumstances, this cannot be used as a judicial precedent in usual regular circumstances. Furthermore, it is advisable that the invoking of this power should not be quoted either as an approving or overruling authorities to substantiate more of such cases. Now, let's see a few cases where Article 142 has been invoked by the court to prevent gross injustice. Bhopal gas tragedy incident. The Union Carbide case was one of the chief instances where the Supreme Court had exercised this unusual power. In keeping with the legal dictum of parens partiae, the court ordered Union Carbide Corporation to award compensation to the victims and placed itself in a position above to the parliamentary laws. Munish Kakkar versus Nidhi Kakkar case. This was a case where the court used Article 142 to order annulment of a marriage in order to provide complete justice. Ayodhya dispute. In this, the Supreme Court had exercised the powers mentioned under Article 142 of the Constitution to achieve complete justice and had passed orders which had not been originally prayed by the parties. It did so because of the complex nature involving a combination of history, religious sentiments and property. So, this was all about the unique safeguard granted to the apex court. We hope Things are more clear to you by now as far as Article 142 and the Supreme Court is concerned.